I'm going to turn this over to Abby.
Hi, everyone. Thanks for joining us today. We are going to hear from two state archives and the Arkansas HIPAA privacy officer about their experience with health-related records. We'll hear from our panelists and then have time for Q&A. So if you have any questions as the presentation is going, please put them in chat and we'll address them once our presenters are finished. So joining us today, we have David Ware, who's the state archivist for the Arkansas State Archives, a position he has held since 2020. Prior to becoming state archivist, he served as the state capitol historian. David holds a bachelor's degree in French literature from the University of Nebraska, a master's in history from the University of Wyoming, and a doctorate in U.S. history from the Arizona State University. We have Chuck Hardin, who is an attorney and HIPAA privacy officer for the Arkansas Department of Health. Chuck has been working in the information privacy world for the last 4 years, first with the Department of Human Services as a privacy attorney, and now in his current role at the Department of Health. Prior to practicing law, Chuck retired from the United States Air Force. Away from his role as an attorney, he enjoys traveling with his wife of 30 years. And we have Alan Ramsey. Alan joined the Connecticut State Library staff in 2010 as a government records archivist. He became assistant state archivist in 2013 and oversees the acquisition, arrangement, description, and preservation of state and local government records and non-governmental records of enduring value pertaining to the history and heritage of Connecticut. He was appointed a member of the Connecticut State Historical Records Advisory Board in 2017. And with that, David, I'll hand it over to you.
Okay. Good afternoon, everyone, or good morning in the case of Karen up there in Alaska. I have a sort of, it's not exactly a shaggy dog story because we actually end up in a different place than where we begin. But this is a story that has gone on as long as I've been at the Arkansas State Archives. Next slide, please, Becky. First off, look at that innocent face there in the middle. This was February 23rd, 2023 at the former Boonville Tuberculosis Sanitarium. Some of my staff met folks from the Arkansas Department of Health and also the proprietors of the Boonville Center for Human Development to take a look at some unknown property, some records that just happened to have been stored in the base of this beautiful old masonry building. Okay, next slide, please. The Arkansas State Tuberculosis Sanitarium was established in 1909, about 3 miles south of Boonville in Logan County in west central Arkansas. The sanitarium was the relocation center for all white Arkansans who suffered from tuberculosis. By the time the faculty was closed in 1973, it had treated over 70,000 patients. And you can see the size of the facility. It grew like Topsy over the decades. The Nyberg building, the main clinical structure on the grounds, you can see it in the left of that postcard view, was 528 feet long, 5 stories tall with a full basement, housed over 500 patients, plus doctors' offices, x-ray facilities, the employee cafeteria, and, not far enough away from that, the morgue. Now, in the 1950s, new drugs to treat tuberculosis resulted in a decline in the center's patient population. Basically, as treatment evolved, as it veered away from long isolation in mountain climbs, the place started losing its patient population, even though it was designated as a children's colony, in addition to its adult patient population. Also, new regimens for TB treatment made long isolation of patients less necessary. In 1971, the Arkansas General Assembly dissolved the sanitarium as an independent agency, and from what I understand, they created the State Department of Health to oversee it. The health department was also put in charge of the McRae Sanitarium at Alexander in Saline County, just west of Little Rock, which was the treatment center for all African Americans with tuberculosis. Separate facilities, of course. Well, time was running out for such facilities. On February 26, 1973, the last 7 patients were discharged from the state sanitarium. And on March 13th, next slide, please. Okay, oops, lost my place. And on March 13th of that year, the legislature approved Act 320, authorizing the facility's closure and the transfer of control from the Department of Health to the Board of Mental Retardation, known today as the Division of Developmental Disabilities Services branch of the Arkansas Department of Department of Human Services. Try saying that 5 times with a mouthful of marbles. Today, the old Boonville Sanitarium operates as the Boonville Human Development Center. Half of the first floor of the old Nyberg building that you see in these 2 photographs is used for offices. The rest of the building is closed, but it is not empty, because when the Arkansas Department of Health closed up shop there in 1973, a trove of patient records were simply left in place in a ground floor storage room of the Nyberg building. The door was padlocked, and there they were left for decades. Now, the Arkansas State Archives first became aware of the existence of these records in, I believe, 2019, before I came on deck here. Our initial contact was with Maria Jones of the Health Department's Office of Administration. She'd worked for ADH for years, had become their unofficial historian. She'd previously organized and transferred records to us, and transferred in 2021 the contents of a Department of Health time capsule from 1969 that we had helped her open in 2019. Maria had a good working relationship with our curator, Julianne Crawford, and mentioned to her in 2019 that a large quantity of records were stored at Boonville. Well, I came on board here in January of 2020, and one of the first things that Julianne mentioned to me was that there might be some things up in Boonville we wanted to take a look at. And so we made arrangements with the staff of the Center for Human Development up there. We first visited the Boonville Human Development Center to see the records on February 18th, 2020, hearkening back to that first slide of those young, innocent faces standing outside the Nyberg building. Health Department staff attending were Maria Jones, Laura Shue, Eric Roberts, and Danielle McNeil, who was a former Arkansas State Archives employee, so she has a foot in both camps. Arkansas State Archives staff attending, Julianne Crawford, our curator, Stephanie Carter, Jane Wilkerson, and myself. Plus, we were met by Vanessa Wyrick, who's the staff development coordinator at the Human Development Center. She was our host and tour guide. Vanessa is also a member of the local historical society. And this group, which has its roots in tuberculosis patients who had stayed up in the Boonville area, as was common in such treatment facilities, they were interested in the preservation of these records and had been reaching out to try to interest others to support their preservation. They maintained, by the way, a list of names of patients that had been published in sanitarium newsletters back in the 1920s and would provide information to the public upon request from sources I have not asked too closely about. Vanessa reported to us that she had contacted, quote, the health department, she didn't say who had told her that the records did in fact not belong to the health department. Vanessa had also contacted the University of Arkansas for Medical Sciences, and she indicated to us that, quote, some physicians from UAMS have visited the records and are very excited, doing research in patient records about the efficacy of treatments and that sort of thing. Next slide, please. Once we went inside the building, well, let's put it this way. This is the nicest, cleanest part of what we saw. We found a large storage room stuffed full of shelf after shelf of records, mostly in alphabetical order. Records that had been removed from those shelves for consultation had simply been piled on top of cabinets, or as you can see in the middle, simply put into a big convenient drum for later refiling. I'm sure they meant to put them all back where they were supposed to be. Now, this was in February of 2020. The archives staff came away from there going, yes, of course those need to be preserved. Yes, they need to be protected. They need to be out of there. But we all know what happened a few weeks after this. COVIDian shutdown slowed things considerably, but the idea remained alive. We made great contacts in the health department. Staff attorney Craig Smith and Chuck Hardin, who you see above me in the lineup over on the side here, accompanied us onto a return visit to the facility. They sampled the culinary delights of downtown Boonville. They went into that room. They came out not visibly traumatized, and they agreed with us that the records should be preserved. The question was where they should be preserved. The health department did not have the records storage facility for such things, or really staff time to devote to eventually processing these records. UAMS initially thought they could handle these records, but on second thought said, no thank you. This left the state archives, who would try to find a way to make this happen. Now, transferring these records was not straightforward because we're not a records management state. Anytime there's a transfer of state records to us, a memorandum of understanding has to be drawn out. We have forms to fill out, basically get approval between our respective hires up to make this possible, because the state archives is not the guaranteed designated recipient of any other state records. However, Craig and Chuck at their end, working with our staff attorney in our parent department, made this happen. A memorandum of understanding was finally drafted and signed in the fall of 2022, and we began making arrangements for the retrieval of these records. The ADH would pay for materials and shipping. We contributed our staff time, our organizational skills, our storage, and eventually our processing. So we are partners in this. Work began on extracting the records in March of 2023, when a team of archivists from here headed up to Boonville for what would turn out to be a camp job. That is a job of several days' duration, spread over 2 weeks. Now, most records, we were happy to find, were still in alphabetical order on those shelves, except for the ones that were in file cabinets or on top of those file cabinets or piled in a corner or stuffed in that circular file you see in the central photograph here. The retrieval crew consisted of Heather Reinold, Julianne Crawford, Jane Wilkerson, Wes Oliver, Rebecca Ballard, and myself. We had pre-ordered bales and boxes full of records, cartons, and other enclosures for these materials, and a team of 5 of us at a time set to work. 1 in the hallway making boxes as fast as possible, 2 in the records room filling boxes. Next slide, please. Others retrieving and stacking the full boxes. There's the hallway. Boy, did we fill it up. Next slide, please. And that's not even as full as it got. That hallway got crowded. Now, what we found were not just patient treatment records in the sense of doctor's notes. We also found pharmacy records, x-rays, death records, and we even found, as an unanticipated bonus, we found records from the Gray Sanitarium, the one reserved for African Americans, which had been closed in 1967. Apparently, many of the records had been shifted north to the Boonville Sanitarium, locked up in the same room as the Boonville records, and there we found them. Okay, next slide, please. As I say, we were enjoying a camp job. At night, we repaired to the modest luxuries of the Countryside Inn of Boonville, conveniently overlooking the Walmart parking lot and a Dairy Queen, where we found mostly recent mattresses, passionate and noisy neighbors, don't go there, as well as microwave-resistant cockroaches and archival-grade mildew on headboards. Good times. See what you were missing, Chuck? But we got these things boxed. In all, in April, we returned to Boonville to oversee carriage of those records to our Little Rock facility. Next slide, please. The final count was about 1,100 records cartons, plus several file cabinets full of smaller records on cards, which we simply wrapped up in shrink wrap and transported in block, as well as a number of ledgers that have been scattered atop the cabinets. It took 3 box trucks to do it, and as per state practice, we went with low bidder. 3 trucks, 3 guys, 2 lift gates, 1 truck that was too low to actually meet our unloading dock back at our facility in Little Rock. And between the 3 guys and the 3 trucks, they brought 1 workable dolly. Thankfully, we had brought most of what we had our Little Rock facility. So we help them get the stuff into the trucks, move them down. They're currently in our records storage facility in Little Rock. They are the boxes have been mostly shelved in alphabetical order. There are still some puzzles, and we've not begun tackling what's in those cabinets yet. This was a great team building exercise, and I say that without the slightest bit of cynicism because I have a great staff. Everybody pitched in to move things around to try to make sense of this. This was a big retrieval. And we are going to spend a long time working with this. And I will say that we did not have much experience dealing with records that might have sensitive medical information on them. Although a couple of our collections have some such information included, such as barbers' registrations and licensing documents, many of which contain the results of their Wassermann tests. Those of you old enough to remember the term, you know what I'm talking about. The rest of you guys, look it up. You're academics. But at any rate, we have a big task before us, doing even minimal processing on these, and then working with the State Department of Health to figure out just how to make these available, to whom these may be made available in the future. And that's when we called out to Chuck over there and said, please, we need HIPAA for dummies. And he has graciously given us a couple of sessions, so our staff has gotten up to speed, at least knowing how much we don't know about patient privacy and confidentiality, and giving us a valuable resource who, oddly enough, has a sense of humor about this sort of thing. And so that's my piece. The questions now are questions at the end of the program, but otherwise I'll bow out and let something more interesting go on. Thank you very much.
And so now we come to the wonderful, fun legal portion. I am Chuck Hardin. I am the HIPAA privacy officer, and I'm an attorney here with the Arkansas Department of Health. Probably I'll start with the first biggest misconception with HIPAA, and that is how to spell it. I see it several different ways. I've seen professionals in the field spell it wrong. So it's always one of those jokes that we like to have. But that's HIPAA is actually HIPAA, Health Insurance Portability Accountability Act. So there's your first bit of knowledge for this seminar. Next slide, please. Again, I'm an attorney, so I'll give you the fine print right up front. HIPAA is the privacy and security floor for medical records. And I say that because some of you will have state laws which are going to provide additional protections. And so that what I am going to talk about is really just a very basic overview of HIPAA. If anything I say is contradicted by your practice, there may be multiple reasons for that, not the least of which is your state may have additional protections. I know the state of Texas has additional laws for their health record. We in Arkansas do not. So we simply abide by HIPAA. And also, I'll give you the attorney statement of nothing should be construed as legal advice. This is just for educational purposes. Next slide. So the main question you have to ask is, does HIPAA apply? And two things are really going to dictate whether that information that you have, that is health information, is covered under HIPAA. And the first thing is who created or holds that record. And the second one was why the record was created. HIPAA applies to covered entities, and those are specifically defined as healthcare providers, health plans, and healthcare clearinghouses. Healthcare providers themselves is a specific definition within HIPAA. And so whenever you go to that, it's going to be more specific than just doctors and nurses that we think. It's going to be based on the services that they provide, not necessarily what they are licensed to do. And then there are those that they contract with, which are referred to as business associates, and they are going to perform services for the covered entity, such as record storage and dispersal, David. Um, so, you know, it's we have a very unique relationship with our archive because we are a covered entity at the Department of Health. And whenever I get to the end of this and I talk about the specifics of this this project, because we are a covered entity, in order for the archives to do this for us and store this and be the ones who will eventually be able to you know provide these records, we needed to have this additional layer and create a business associate agreement with them, which is, you know, they're not generally equipped to handle HIPAA. So they're not going to have a privacy officer, which HIPAA requires the agency to have somebody who's in charge of policy as well as can handle complaints. That's where I step in. So I have been their de facto HIPAA privacy officer as well as the Department of Health's HIPAA privacy officer. So what information is covered under HIPAA? Well, the term of art they like to use is protected health information, or PHI. And that is information that is created by the covered entity and relates to past, present, or future physical and mental health, blah, 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 blah. It is generally medical records, it's safe to assume that, but it can be more than that because it's also the billing information. It also can be the demographic information and other things along those lines. So some things that may not be protected health information, while we would think, things like drug screens. Drug screens for employment are generally not considered protected health information, while they may be protected under a different law. Also, as David brought up, some of the medical information in licensing applications would not be considered protected under HIPAA. And that's because they're not, once they leave that covered entity, and there could be several different reasons why it leaves. One is required by law. It could be simply, I know here we have a couple of things where the applicant for the license has to provide the information. Sometimes that information is a certified patient letter from a doctor. And so while that would be considered HIPAA protected for the doctor, the holder of that information, as far as the license goes, is releasing that information. And therefore, now you have a state agency that has protected health information. They're not a covered entity, and HIPAA no longer applies. Next slide, please. Some other notable exceptions. There are actually several that HIPAA outlines that don't require, that the release of health information wouldn't require the patient's right to either control that or to provide it, or requires an authorization. Those exceptions, the first one is medical records when the patient has been deceased 50 years. This is a really important for our project here. Once the patient has been deceased 50 years, the records are no longer protected under HIPAA. They're no longer considered PHI. Another notable exception is de-identified records. And that isn't just records that have been redacted, but it can also be determined that de-identified records are records that could not be re-identified based on the information available in them. And the example I like to use is if you have records from John Smith in Little Rock, Arkansas, and no other identifying information, then it could very well be likely that those records would be considered de-identified because it is very, very difficult to identify who that John Smith may be. Now, that's going to take a little extra work, but that is one of the avenues that HIPAA provides. The next thing is court orders. Orders can authorize the release, and then a lot of times in court, you'll also have other protections added to, but HIPAA recognizes that as an exception. And then the last one is kind of important for what I do, and that's public health. And also, if you have a public health function that is providing records in an archival sense, then they have already gone through the exception. And if they are for public health purposes and public health records, then HIPAA will not apply to those, although they will contain medical information. Next slide. So Boonville, from my perspective, this is where it gets fun. This project started a couple of years before I got to the Department of Health. And so how did I get involved? Well, as I said, we have no state law specific to this situation. I know, as I said, some states do. So that's whenever they brought in me as the HIPAA privacy officer and told me about these records that were sitting here in this basement. And my first response was kind of shock, because we were going to retrieve these records. They were decent records. They'd already been looked at, and folks were confident that we could save these records. The mere fact that they exist is a surprise. Almost all privacy officers would tell you that the cleanest, the simplest, the safest thing to do is destroy them. And now everybody cringes, and I understand, but from a security standpoint, HIPAA would allow that, and that would be the safest, cleanest, easiest way to do it. David knows I have a son who is a historian and works in a museum in the state of Arkansas, and so he grew up with my interests in history and such. So I walking in, I immediately saw the value in these records, and that was never going to be an option for me. I wanted to make sure that we found a way to make this work. So David pointed out the timeline for this. HIPAA wasn't enacted until 1996. So why do these records fall under HIPAA? The hospital closed in 73. Well, before the hospital closed, it became part of the Arkansas Department of Health. And we never did anything with the records. And then in 1996, whenever HIPAA was enacted, we became a covered entity. And when we became a covered entity, that means all of our medical records are now protected under HIPAA. Lo and behold, we open up this basement and we still have all of these records. So therefore, they apply, and they are protected health records. We actually had another hospital in the state of Arkansas. It wasn't a state facility. It was a privately run facility that went bankrupt. They decided to close the doors one day, and that was it. And the building was left to the devices of others, and it was broken into. Things were scattered. Things were able to, as far as elements and weathers and raccoons and everything you can imagine. And those records had to be collected by the General's office, and we helped with that with the Department of Health, while the Attorney General's office went after the former owners of this hospital to ensure that they were taking care of their responsibilities, basically. And they ended up having the court order them to properly dispose of these records. Now, this was a private entity, and those records were really beyond salvageable. But it just goes to show, this closed in 73, and thankfully, what would be the Department of Human Services took over the facility, so it was maintained. Any leaks, any access to the outside was minimized, which really helped in the preservation of these records in this state. So I don't think anybody else in my role will have encountered this or will encounter it in the future, especially since we've gone to digital records. It's not going to be something where we're going to see this. And I would be I would be surprised if there's not one or two, or if there's any more than one or two out there that may have done this. So it does. It creates a very unique relationship with our archives, because they are our business associate as well as their usual job. That's going to provide, that's going to create some issues for me, because HIPAA does apply. HIPAA does apply to these records, and so I have to follow HIPAA whenever it comes to the release of these records. One of the things we've talked about doing is as they start cataloging these records, is we're going to have to identify whether or not there are individuals deceased. And I think there were 7 or 8 file cabinets that were already filled with deceased records, and they were dated. So we already know that once this project starts in the next phase, those records are already going to be open to the public, and they're going to be able to review those records because the 50 years has passed. The question becomes, if we don't have death records in these records indicating that the 50 years has, then I have to reach out to my vital records department, find out if we have death records, and start putting policies in place on how that's going to. And that's what David and I have, we've already done some training, and I've already made myself available that if there are questions, we can certainly handle those. So that's, I have a next slide. Nope, that was it for me. So that's really my perspective on it. As I said, it's a for me, it beats the day in, day out people complaining about, whether or not somebody released records or whether they didn't. This is really a fascinating avenue for me to venture down.
All right, thank you, Chuck. And next slide, please. So I'm just going to talk about a few instances real quick about 2 things that have come up in the past that really led us into this issue of working with various patient records. So on the left-hand side, you see Civil War veterans. So I'll start there. So in 2009, Professor Matthew Warschauer at Central Connecticut State University, along with students, wanted to research for the anniversary of the Civil War. Really wanted to dig into what they called back then soldier's heart, what we today would call PTSD. And so he was wondering and researching into what we know today as the Connecticut Valley Hospital. It's had various different names prior to that. It's still actually an operating state mental health hospital. And so they started wanting to do research. And so around that time, we had transferred some of the records, because these records were, as David and Chuck were just describing, these records were in buildings that were falling down or about to fall down. And they've over the years, the institution has, of course, created new buildings, and they've tore down old buildings. So anyways, there was a transfer of records, some records that were found, primarily registers, and we had transferred some patient files prior from our state record center to some of the earlier patient files from the hospital. CVH itself started back in the mid 1800s, so it had already had a long history. So he was starting to work with students on this, and he wanted to see additional records because we, of course, didn't have all of the records. So he went to our Department of Mental Health and Addiction Services and said, "Hey, I'd like to do research on this topic." And they said, "Well, sure, but you have to remove all names," and that's not what they're looking at. They're looking to kind of profile the soldiers' experiences from before the Civil War through their experience after the war. So they and they also were saying that they didn't probably have any records helpful. And so in 2009, he was running into a lot of issues. So in that same year, he filed the Freedom in Connecticut, you can file a Freedom of Information Act request. So he did that in 2009 as well. And so that process started, and then that was took a few, take time. So in I believe it was in 2010 that Freedom of Information Commission ruled in Professor Warshower's favor for most of the records, but then it got into where our situation comes into play, which is in 2011 during the General Assembly session. There was that year a bill proposed to add to the Freedom of Information Act exemptions all records, tax returns, reports, and statements exempted by federal law or the general statutes, or communications privileged by the attorney-client relationship, marital relationship, clergy, parishioner, or penitent relationship, or any other privilege established by common law or general statutes, including any such records, tax returns, et cetera, created or made prior to the establishment of the applicable privilege under common law or the general statute. So basically, it restricted everything. So even at the archives here, we had to go back then. So that was a bill proposed. The bill didn't go anywhere, but that language, and I should also mention real quickly that the attorney-client privilege was already established in the exemption, so that was already there. They added the other relationship exemptions, and so the bill didn't go anywhere, but this got tucked into a technical public health bill as Section 37. So it was not easy to find, but it was there and passed through the legislature. So that effectively ended Professor Warshower's work in this area. The other thing you'll see on the right here is the Amy Archer Gilligan case. So about the same time, and I'll just say quickly here. So about the same time that Professor Warshower's Freedom of Information Act request and all that was going on, we had a different researcher, a writer, Ron Rolbard, who wanted to tell the story of Amy Archer Gilligan. From 1924 through 1962, Amy was a patient at CVH, and following her conviction for second-degree murder for the arsenic poisoning of residents of her nursing boarding home. This is also widely considered to be the basis for the play and movie entitled Arsenic and Old Lace. So he was interested in telling Amy's story. He first made his request in 2010 as well to the FOI, Freedom of Information Commission. The commission ruled that some of the records were, I should back up real quick. Interestingly, the Department of Mental Health and Addiction Services had released some of the records previously that they didn't, that had released some of the records, but they were withholding other records. So the FOIC did an in-camera inspection of those records and determined that some, yes, meet the privilege requirements under the law. So, some could be construed as medical records, and then some should be disclosed. The department then appealed this to the courts, and I won't go through all the court litigation, but essentially it went all the way to state Supreme Court, and the majority opinion was that her file, because they had a patient file for her, was considered medical records. However, there was a dissenting opinion. So fortunately, we did have a dissent in this case, and the dissent was that yes, some of this might be medical, but some of it is more correspondence related, and you've already released some, so how can you claim the whole file is medical? And I'm really shortening up the dissenting opinion, but that's sort of a little bit of the background in this. I won't go too into it because it gets very there's a lot to it. But anyways, next slide. So this just shows some of the exemptions and statutes. As I mentioned, why don't we go to the next slide, please? So now I'm going to talk a little bit. So this, as I mentioned, was signed into law in 2011. And so we then started to work on attempts at legislation. And so and I should, first you'll see it from 2010 to 2011, we did, as part of the State Historical Records Advisory Board, we began an access advisory committee to start to talk with historians and interested parties across the state about how we might attempt this. We collected data about what other state laws looked like, talked to other state archives, talked to other states, gathered all that data together and started to make some plans. You'll see the next thing is in 2014 was our first attempt at an act concerning the preservation of historical records and access to restricted records in the state archives. All of these bills, I should mention, have gone through the Government Administration and Elections Committee. This is the committee that has oversight over the state library, which is where the state archives is housed. We helped to draft that first bill, and our first attempt was to lift the exemptions on the records in the state archives, only specifically the state archives, after 50 years after the death of the individual who was subject to such record, except that the name of, excuse me. So we were looking at 50 years. What ended up happening in 2014 was one of the state senators proposed an amendment. The amendment was adopted by the committee that then added on to the bill that except that the name, address, and social security number of such individuals will be redacted. So we halted our efforts in 2014. And then the next time was 2016. And that, so in 2016, we actually had the chair of the GAE, Representative Ed Jatilla, actually raised the bill that had previously been raised without the amendment. And we thought, great, we have one of the co-chairs of the joint committee sponsoring this. And Representative Jatilla was in his last term. He was going to retire from being in office. And so we thought, great, we have somebody who's going to get this through because they're going to, they have interest. So it got through committee, the bill that we wanted. During that, we testified in the public hearing. We also did some follow-up emails and letters to the various chairs to provide some clarity on remarks made in the public hearing, such as everything is going to be open. We had one individual tell a story about their family member who had been in an institution in another state. I believe that was in 2016. So we did some follow-up. The bill made it out, like I said, made out of committee, and it made it to the House floor, and then it never made it on the calendar. So in 2017, we tried again. And I should mention too, in all of these attempts, we work with outside stakeholders such as our Connecticut Freedom of Information group, that CFOIA group that helped advise us on sort of how to do some of this work with legislators because they had some experience. We also worked with Professor Warschauer, who raised some of this as well. I think if I remember correctly, the 2014 effort was partially his push. So we had made it to the House in 2016. 2017, State Archivist Lizette Pelletier asked her local representative, Whit Betts, to place a holder bill. These are allowed in odd years or long sessions. Legislators can throw any sort of topic into the hopper. So we got the placeholder in place. We went through to we worked with our outside groups on how we were going to approach the public hearing. We went to the public hearing. We had changed, at this point, we also changed the language of the law. We thought, well, 50 years doesn't seem to work. We'll change it to such record was created 75 years or more prior to the date the request to inspect such record, or the date of the request to inspect such record occurs 75 years or more after the death of the person who is the subject of such record. So we, like I said, we had a public hearing. We had the similar opposition as the previous times in the public hearings, although the Department of Veteran Affairs also testified in opposition to the bill, that because they recommended recommending additions of language to the bill, clarifying that access or to public medical or other treatment records by individuals served by state agency be redacted of PII to protect the privacy of the individual unless the request for the information is made by a family member. And then we sort of, I believe it got out of committee, but I believe it wasn't voted out of committee, and we ran into some oppositions from one of the state senators on the committee. So it sort of dropped there. And then in 2019, we tried again, similar language. And just looking here real quick, I don't believe that even made it a vote out of committee. So, but each time we took away lessons and of sort of how we approach this. We haven't attempted since COVID hit. We hope to attempt in the next long session, because short sessions are really tricky to, in short sessions, which we're in right now, typically leadership has to introduce the bills. They have a short window to do that. So, and we've been looking at introducing legislation next session, potentially on this again, working with our stakeholders again. And then Lizette and I had, as some of you may know, had presented at CoSA in CoSA in DC this summer, and we took away some good lessons from there as well, and talked with all of you about reaching out to the community about this more, to sort of communicate what we're trying to accomplish, listening to them, absolutely, respecting privacy, respecting the exemptions in law. I should also note we did talk once with leadership at the Department of Mental Health and Addiction Services about this. After 2 hours of talking, we didn't reach any sort of agreement. So we've made some attempts, and but that's sort of our attempts at trying to open up the records. We hold records from 3 state mental health hospitals. 2 of them we have patient files from, not full runs, but partial runs of patient files. And so trying to open those up along with other medical records from other state agencies has been one of our things that we've been trying to work on for years, as you can see, for years now. So with that, I'll turn it back over to Abby and for questions and answers. Thank you.
Thanks, David, Chuck, and Alan. We have a couple questions already in the chat, and then we're working on unmuting one of our participants. So I'm going to start with the chat question while we finish working on that. A question for Chuck, which is, if the records had been transferred to the archives prior to 1996, would Department of Health still be considered a covered entity? For instance, what if they were archived in the 1980s?
No, that's part of the timing. If they would have been found and sent over, and I think Sarah had an FYI below that with her Department of Health and Human Services, that is exactly on point. If we would have known and transferred those before HIPAA came into place, they would have been the archives records at that point in time, and HIPAA would have not applied.
Thanks. Sorry, I'm just writing that down because that's the question I had too. And then another question for you, Chuck, is Arkansas a state that transfers death records or other vital records from health to the archives once the filing and review period is complete? And then what is the rationale for transfer, not transfer, or delay?
No, we don't. And I would say that and David, you can add your 2 cents if you want, but I would say that the rationale is that statutorily we're responsible for it, and there is no statutory mechanism to send it over to the archives. So we maintain them ourselves.
That's it, right on the nail head, Chuck. Since the state archives is not a records management agency, departments and agencies tend to hold to their statutory duties and not take advantage of us being a convenient partner for them. I know that we refer people, the vital records folks refer people to us to get an indication of whether or not someone is dead, and then we send them back to vital records so they can get the official certification. It's a good cooperative arrangement. It means everybody gets a little business, right?
All right, can we please unmute Andrew so he can ask his question?
Andrew, I think we've given you the ability. I think all you have to do is unmute yourself at this point. And Andrew, while you're figuring that out, let's call on Sarah. I think she's unmuted.
I am. Thank you. Thank you guys for this presentation. This was really helpful. And I learned a lot. My question is for Chuck, and it might have a couple parts to it. Are you able to share the BAA that you used, or the language, if that was incorporated in the MOU with the Arkansas State Archives? I asked because I'm wrestling with this with my own Department of Health and Human Services, and kind of my follow-up question is, how do you manage the pieces of a traditional BAA agreement that are incompatible with historical records? Because I think a lot of the templates I've seen are designed for electronic health records and not paper records.
Okay, so the first part, yes, I could share that with you. I will tell you that it is highly based on what is, the template that the Federal Health and Human Services puts out. But yeah, I would be happy to share that. I did have to make some changes again because traditionally a business associate is in the healthcare field, and so they're already familiar with these things. They already have processes in place, whereas our archives, as wonderful as they have been, this is brand new territory for them. So really it was to make this work, we at the Department of Health had to take on extra work and understand that this wasn't going to be a traditional business associate agreement. And so that may be one of the things that you're going to have to encounter as well, is that your Health and Human Services is going to have to do a little more lifting than they would normally if it was, say they were contracting with Ciox, is a company that handles the release of patient information for hospitals and providers. That's really easy to just contract with them, put the provisions in, and let them go to town and do their job. This is a different situation because, again, the archives aren't familiar with this. They're not living in this realm. So that's kind of my thought process on that.
Yeah, thank you. Actually, our problem is the reverse. It's my own legal department, because our Human Services said, draft something for us, because there are pieces of our state law that are incompatible with that BAA. So for example, when records come to us, there are custody, so we can't have them dictate to us what happens to them after they're transferred to us. And my department won't draft anything, so I'm looking for some examples.
Well, and so that may be, yeah, that's an interesting one. Custody is a tricky term in the law. So because you have like physical custody and you have legal custody.
Right.
So who actually, which custody are we talking about here? Just to put on the lawyer hat for you.
Yeah. And that's it. The custody is fully ours after they're transferred to us by state statute. So yeah, everything you said fits with what our DHHS HIPAA attorney said. So I'm very relieved about that. But I'd appreciate a copy of the BAA, and I can put my email in the chat. Thank you.
Okay, that'll work.
All right, we have a question for Alan. What was mental health's main reason for not allowing a sunset for opening the records?
So yeah, John, thanks for the question. So in talking with the commissioner and their legislative individual, it came down to that the individual did not have the choice on whether their records would be made available or not. And usually the opposition in the public hearings was along, not necessarily along the choice phraseology, but more along not understanding what we were intending to do. They didn't see that it was specific to state archives. They thought it meant that this would open up all records. So usually the testimony was, I don't want my records out there. And we're like, no, we wrote it specifically that it only applies to the state library, the state archives, very specific, very narrow, but it was still a concern about, it's going to allow anyone to get my medical record from the current, my current stuff. And it's like, no, that's not what we're intending to do. So that was some of the pushback.
Thanks. And I think we have time for one last question. It's for David. What was the total extent of the records you collected from Boonville?
If you mean the physical extent, as I say, just shy of 1,100 records cartons, plus, I would say, I'm trying to remember either 8 or 9 full-sized, legal-sized file cabinets full, plus a number of smaller card file cabinets full, plus about 20 boxes full of ledgers. Quite honestly, we have not gone back, other than getting things on the shelves in our remote storage facility. We have not really come to terms with the enormity of what we have over there. Chuck just did his HIPAA training for us, and we didn't want to loose any of our staff on that until we had that for them. So we're going to be doing some exploring in months to come. Adventure time.
All right, thanks, David. Lisa, back over to you.
Thank you, Abby. Well, this was a really great presentation today. Lots of really good questions, lots of participation from everyone. And I've asked Chuck to send me a copy of the agreement as well. So if you later said, oh, I really wish I'd asked him for one, you could reach out to CoSA, and Joy and I will figure out where we can place it to make it available for you. So I appreciate your next slide, Becky. So what do we have in the future? If you enjoyed this webinar, I hope you'll come back for more of our member webinars. We've got a really interesting 2-part series in March and April on hiring at the archives. And our first one is going to be about attracting applicants. And it's going to be for state archives institutions and kind of how we're crafting things and how we're reaching out and how it's being perceived, et cetera. Then part 2, we're actually going to reach out to students and help them maybe walk through the process or understand why the process through the states either takes longer, or what they should expect, or the fact that they're not going to hear from anyone. And then in May, we've got the Christmas Leak at the Colorado State Archives. So if you're interested in any of these, I believe the links are up at the webinar. Please go on and sign up for them. Next slide. We have a whole bunch of Siri webinars planned as well. They're not yet up on the website. I'm sure they'll be there soon. So, but do go check those out. And again, you can sign up for them as well. Next slide. As always, there's lots of ways to contact us through CoSA. And so you can always check out our YouTube channel, because this recording, along with all of our other webinars, are posted on our YouTube channel. So if you can't attend live, you can always watch it, or you can watch it rebroadcast if you say, I missed something, I want to go back and watch it again. Next slide. Naturally, we couldn't do the work that we do with CoSA without the help of our funders. And finally, Becky, the now slide, and of course, our sponsors. So we'd like to thank all of them for their support of CoSA as we do all of this work. And then the last slide. We want to thank you all for participating today, and we believe there'll be a survey coming at you, and we do hope you'll provide some feedback. It really does help us as we plan things and go future. So thank you, panelists. I appreciate all your time. Anybody have any last words? If not, thank you so much for joining us today. We'll look to see you at our next CoSA member webinar. Take care, everyone.